Welcome! In today's video, we're exploring the Mental Capacity Act 2005, a vital law that protects and empowers people in England and Wales who may struggle to make certain decisions for themselves. Whether you're a health or social care professional, a caregiver, a student, or simply someone who wants to understand how capacity and consent work, this video will break down everything you need to know in clear, practical terms. By the end, you'll understand what mental capacity really means, how to assess capacity fairly and lawfully, what best interests decisions are, the key principles professionals must follow, and how safeguarding and advocacy fit into the picture. Let's dive in. Mental capacity is simply a person's ability to make their own decisions.
Under the Mental Capacity Act 2005, every adult is assumed to have capacity unless proven otherwise. Capacity is decision-specific and time-specific, meaning a person might be able to make some decisions but not others, or may regain capacity later.
These decisions can range from everyday choices, like what to wear or when to see a doctor, to major ones, such as managing finances or consenting to medical treatment.
What is consent? Consent means saying yes to something voluntarily and with full understanding.
For consent to be valid, the person must understand what they are agreeing to, why it's needed, the possible outcomes or risks, and any alternatives available. If someone gives permission under pressure or without proper information, that's not true consent. The Mental Capacity Act provides a clear legal framework through the Court of Protection, the Office of the Public Guardian, and the Code of Practice to make sure decisions are made fairly and transparently. Court of Protection and Public Guardian. The Court of Protection handles cases where there's disagreement or uncertainty about a person's best interests, whether it's about healthcare, finances, or welfare. Meanwhile, the Office of the Public Guardian protects people who lack capacity by overseeing their financial affairs and supervising deputies or attorneys appointed to act on their behalf. This code is the how-to guide for professionals. It explains how to apply the Act's principles in daily work and ensures decisions made for others are lawful, respectful, and properly recorded. Ignoring the code could result in legal consequences, so it's essential for all health and social care professionals to follow it carefully. The 5 key principles of the Mental Capacity Act. 1. Assume capacity unless proven otherwise. 2. Support decision-making. Give the person all practicable help before concluding they lack capacity. 3. Unwise decisions don't mean no capacity. People have the right to make choices others might disagree with. 4. Always act in the person's best interests. 5. Choose the least restrictive option to their rights and freedom. Assessing capacity. If there's doubt about someone's capacity, an assessment must be carried out. There's a 2-stage test. 1. Is there an impairment of the mind or brain? For example, dementia, brain injury, learning disability, or mental illness. 2. Does that impairment stop the person from making a specific decision right now?
To answer this, assess whether they can understand the relevant information, retain it long enough to decide, use or weigh it in their thinking, communicate their decision in any way. Best interests. When someone truly can't make a decision for themselves, professionals must act in their best interests.
That means considering their values, beliefs, wishes, and consulting with family or others who know them well. Never make assumptions based on age, appearance, or condition. Always ask, what would this person want if they could decide? Is this the least restrictive option?
When a person lacks capacity and has no one to speak for them, an independent mental capacity advocate (CA) steps in.
The IMCA ensures the person's rights, wishes, and values are represented, especially in serious medical or accommodation decisions. They can also challenge decisions if needed. An IMCA is someone appointed by an independent advocacy organisation on behalf of a local authority or NHS in the UK to support a person who lacks capacity but has no one to speak for them.
The IMCA makes representations about the person's wishes, feelings, beliefs, and values, at the same time as bringing to the attention of the decision maker all factors that are relevant to the decision. The MK can challenge the decision maker on behalf of the person lacking capacity if necessary.
An IMCA must be instructed and consulted for decisions about providing, withholding, or stopping serious medical treatment. Decisions about whether to place people into accommodation, for example, a care home or a long-stay hospital. Decisions about whether to move people to different long-stay accommodation. An IMCA may also be instructed and consulted for decisions about care reviews and when safeguarding adults are at risk. An IMCA cannot be used when a court-appointed deputy or LPA exist.
Code of conduct. It is important that involved individuals, including health and social care workers, get to know the IMCA Code of Conduct. These questions are answered in the Code of Practice. When should professionals be involved in assessing capacity? What if someone refuses to be assessed? How can someone challenge findings of lack of capacity? How can someone withdraw an advance decision? What happens if the IMCA disagrees with the decision maker?
The Act also recognises advance decisions, where someone, while they still have capacity, can refuse specific treatments for the future.
Similarly, a lasting power of attorney, LPA, allows a person to appoint someone they trust to make decisions on their behalf about health and welfare or property and finances. The LPA is a legal document registered with the Office of the Public Guardian, where you can say in writing who you want to make certain decisions for you, if you cannot make them for yourself. There are two forms of LPA. One for personal welfare, which includes health care and consent to medical treatment, and one for property and affairs, including financial matters.
The LPAs are executed by representatives called attorneys, who must act in the best interests of the person lacking capacity. An attorney for personal welfare cannot make decisions about property and finances and vice versa. An attorney will be issued with a certificate to prove their role by the Office of the Public Guardian. This should be verified to ensure appropriate authority.
Deputies are appointed by the Court of Protection to make certain decisions for those who lack mental capacity. The Office of the Public Guardian supervises the actions of deputies. The remit of a deputy is decided by the court and limited to the specific function or functions for which the person lacks capacity, though this excludes the power to refuse consent to life-sustaining treatment. A deputy is only appointed if it is deemed in the best interest. A deputy will not be appointed if an LPA exists. The Act created new offences for ill treatment or neglect of someone lacking capacity, with serious penalties. It also sets rules for restraint and deprivation of liberty, ensuring any actions are necessary, proportionate, and always in the person's best interests. Children and young people have special definitions and provisions under the Act. Children are those under 16 and are mostly excluded by the Act, except where the Court of Protection may decide about a child's property or finances if the child lacks capacity and is likely to remain incapacitated on reaching 18. Young people aged 16-17 are covered by the Act in all areas except making lasting power of attorney, advance decisions, or wills. For anyone working in care, the Mental Capacity Act isn't just law, it's daily practice. Every care plan, every medical treatment, every safeguarding decision must consider, does this person have capacity? Are we acting in their best interests? Are we following the least restrictive approach? When documented properly, this not only protects the individual, it also protects professionals from legal liability. The Act allows carers, healthcare and social care workers to carry out certain tasks with protection from liability provided the principles of the Act have been adhered to and there is evidence recorded as to how you are acting in the person's best interests. These tasks involve the personal care, healthcare, and treatment of people who lack capacity to consent to them. The preparation of a care plan should always include an assessment of the person's capacity to consent to the actions covered by the care plan, and confirm that these actions are agreed to be in the person's best interests. This will give the health and social care staff protection from liability, provided they have adhered to the principles of the Act. The person's capacity and best interests must be reviewed regularly. The Code of Practice indicates that, if there are issues concerning capacity, it is good practice for a care plan to be prepared by a multidisciplinary team. All assessments should include the following. Does this person have capacity to consent to care or treatment? Is the care or treatment assessed as being in their best interests? Does an IMCA need to be instructed? The Act introduced a new criminal offence of ill treatment or neglect of a person who lacks capacity, including both adults and children as defined by the Act. A person found guilty of such an offence may be liable for imprisonment for a term of up to 5 years.
Restraint is only permitted if the person using it reasonably believes it is necessary to prevent harm to the incapacitated person, and if the restraint used is proportionate to the likelihood and seriousness of the harm.
Safeguards provide a framework for approving deprivation of liberty for people who lack the capacity to consent to treatment that, in their own best interests, can only be provided in circumstances that amount to a deprivation of liberty. The safeguards legislation contains detailed requirements about when and how deprivation of liberty may be authorized. It provides for an assessment process that must be undertaken before deprivation of liberty may be authorized, and detailed arrangements for renewing and challenging the authorization of deprivation of liberty. Best interests. If somebody cannot make or be assisted to make decisions for themselves, the decision must be made for them in their best interests, and in the way that least restricts their rights and freedom. Best interest checklist. Do's. Consider all the relevant circumstances. Consider whether or when the person will have capacity to make the decision. Support the person's participation in any acts or decisions made for them. Consider the person's expressed wishes and feelings, beliefs and values. Take into account the views of others with an interest in the person's welfare, their carer and those appointed to act on their behalf. Don'ts. Don't make assumptions on the basis of their age, appearance, condition or behavior. Don't make a decision about life-sustaining treatment motivated by a desire to bring about his or her death. Advance decision. The Act gives legal recognition to advance decisions. This is when someone with capacity decides that they do not want a particular type of treatment if they lack capacity to decide in the future. Advance decisions must be about treatment the person wants to refuse, and when they want to refuse it. If the advance decision refuses treatment which keeps the person alive, it must state this clearly and be signed by the person, or by another, with the person's agreement and in their presence.
Individuals lacking capacity may be invited to take part in research. There are strict rules that govern this. It must be safe and relevant to the condition, aimed at helping sufferers. Harm and inconvenience must be minimized. There should be no noticeable objection by the individual, and the research must be stopped upon objection, and family or other involved individuals must consent.
Exclusions to the Act. The Mental Capacity Act does not cover decisions on marriage, civil partnership, personal relations and sexual relations, voting in an election, parenting and adoption, and being a witness in court. The Mental Capacity Act 2005 is about more than just compliance. It's about respecting human rights, dignity, and autonomy. By understanding and applying the Act's principles, we make sure every person, no matter their mental capacity, is treated fairly, compassionately, and with the respect they deserve. If you found this video helpful, don't forget to like, share, and subscribe for more educational explainers on health and social care topics. Together, let's continue to empower and protect those who need it most. Thanks for watching.